The Family Court of Australia is the court of principal authority in Australian family law. The original Family Law Act of 1975 began the cornerstone of the family law court system in Australia. Family Law Act is a Commonwealth Act that establishes an area of federal law that is exercised by a number of different courts, which applies to all Australian states and territories excluding Western Australia. The Family Court of Australia has jurisdiction to hear and decide on disputes in relation to parenting arrangements after separation, in relation to the sharing of property and financial resources after marital breakdown, and the de facto relationships. The Family Law Act was a major change in family in Australia. The Act removed the concept of fault in divorce and replaced it for only one grounds for divorce, that being the relationship was beyond repair, making the process non-adversarial and replacing the matrimonial cause. The Family Law Act was sustained for 20 years due to the effectiveness in achieving justice for individuals and society relating to the family. The 1975 amendment introduced no-fault divorce, in which divorce can occur when no parties are at fault, the only condition being that the relationship is irretrievably broken. Prior to the amendment, a person filing for divorce would be obliged under the Matrimonial Causes Act to prove one of 14 faults to be granted a divorce. If a fault could not be proven in the marriage, a 5-year separation period would occur. This separation time was most dangerous for spouses as the control dynamic in the relationship shifts. Violent partners typically attack their spouses within this time, as in the case of Ingrid Poulsen, in which there was a long history of violence in the relationship and police contact was made on many occasions. Yet the failure by authorities to make an arrest led to Poulsen's estranged husband entering a house and killing her two children as well as Poulsen's father. This violence against spouses as well as no-fault divorce contributed to the original 5-year separation period being led to 12 months in the Family Law Act. Although spousal violence still occurs during this time, it is an example of the community changing the way their families interact in society, changing the law. As family values evolve, so does the law. Changes have been made to existing legislation, new legislation has emerged, changes to court proceedings have occurred, and demands upon legal practitioners have increased. To ensure the legal system is effective in dealing with family law issues, the original Family Law Act reformed the Family Law Reform Act in 1995 in order to be truly reflective of public morality. Since the passing of Family Law Reform Act, it is now embedded the principle of the best interest of the child. The law has continued to develop the rights of children in family dispute and ensures parents to meet their parental responsibilities of their child, especially during and after the process of dissolution. The Family Law Reform Act changed the essential terminology around guardianship of children and further developed the concept of parenting plans and extended in which the law is reflective of the community's values and ethics. In its attempt to deliver the outcome of family members can be illustrated incorporation of the principles of the United Nations Conventions on the Rights of the Child, promoting the Australian Parliament to cement the best interests of the child in legislation by the Family Law Reform Act. This reflected the Australian community's shared sense of public morality on the rights of the child and the international standard. Family Law Amendment Act of 2006 was introduced to engage with the community's changing morals, values and ethics surrounding the responsibility of parents with children in divorce. Prior to the 2006 amendment, fathers were required to pay child maintenance fees to mothers due to the presumption for mothers being primary caregivers of the family. Lobbying to the Howard government by groups such as Lone Fathers, a sole parent group for fathers, wanted to have the law reflect fathers as primary caregivers of children. The lobbying for this amendment coincided with Australia's signing with UNCROC, in which Article 9 states, children must not be separated from their parents unless it is not in the best interest of the child. Every child has the right to stay connected with both parents unless it is not in the best interest of the child. The amendment works to give each parent equal responsibility for the impact decisions of the child, yet the court is not gated to allow shared custody of children if it is not in the best interest of the child. Although courts strive to provide shared custody, in the case of Lewis v. Wackett, the Court of Australia refused to make parenting orders of shared custody where the risk of physical and emotional harm could incur, this overriding any presumption of equal shared parenting. There were objections to the amendment, mostly through advocacy groups for mothers and fathers. The primary objection came from the fathers' advocacy groups, in which they believed that mothers were given the benefit of the doubt in shared custody cases. The introduction to the concept of compulsory mediation emerged from the 2006 amendment, The role of mediation is for couples to discuss issues and the divide of assets before entering the court. This reduces lag in the family court since the drive for mediation. Only 5% of cases progress to the courts after mediation. The mediation program also suits the best interests of the children to have a civilized conversation with a guiding professional in a comfortable environment. The long-term resource efficiency of voluntarily agreeing to the cause allows the individual to be more inclined to compromise with the situation and come to a harmonious agreement. A 2011 amendment to the Family Law Act sought to broaden the definition of domestic violence beyond solely physical violence and to include emotional, financial, psychological, and violence against family pets. This push to identify family violence as a spouse attempting to gain complete control over another expanded the community's knowledge of what domestic violence is. As of 2016, White Ribbon completed an inquiry into police involvement in domestic violence across Australia, finding that on average, a police station is called every 2 minutes in regards to a domestic violence situation. As well as increased reporting, there has also been an increase in the responsibilities of institutions in which must have a mandatory report obligation. This includes schools, doctors, and therapists. The amendment also increased the communication between the state and federal courts, as before the amendment there was no responsibility by the federal court to report and communicate the decision to the state court. This caused inconsistencies as well as lags in the system, requiring more time to understand the processes of other courts. The 2018 amendment to improve cross-examination in domestic violence cases was sought out to create appropriate protection for family members of violence. It concluded that in certain situations, victims of family violence did not have to testify, and that the testimony could be conducted by legal representation provided by legal aid or privately, as well as the option for victims to be digitally examined. The amendment was campaigned most notably by Rosie Batty, former Australian of the Year and campaigner for the government funding of family violence prevention. Prior to 2018, the offender had the ability to cross-examine the victim on the stand. This is no longer able to occur thanks to the amendment. As well as providing institutions for people experiencing family violence, the Australian government has provided financial assistance to improve the state and federal system, thus allowing victims to use digital cross-examination as well as provide a higher quality of legal representation. Family law in Australia has evolved heavily from the original Act of 1975. As Australia's morals, values and ethics continues to change, so does the legislation.